what your baseline experience is. I'd like to move along, if we could, to look at the local laws and ordinances, and Richard and John, just get your input as to, we'll start with the town of Cape Vincent and our local ordinances and comprehensive plan. Could you comment on areas that you feel that you would ask the siting board not to apply? When I say areas of the law, or specifics of the law that you would ask the siting board not to apply.
Sure. So when we submit the preliminary scoping statement, we will have a list of laws that we think that we will potentially be asking the siting board not to apply.
Potentially or actually?
Well, potentially, it'll be, that it will encourage a dialogue over which laws can ultimately be applied, which laws can't. But I think to go through them, generally I think you have section 3.4, which has a certain lot requirement for acreage minimum, frontage minimum, setback minimum, maximum height. Section 3.5. Wax are not a permitted use in a light manufacturing district. So to the extent we have any turbines in a light manufacturing district, which I don't know if we actually do or not. That's when I say, like, potentially we may get to a point where we don't trigger that provision of your law at all because there's no facilities or infrastructure in that district. Section 4, lot uses. 4.1, there's only one principal use per lot permitted. Accessory uses must be compatible with the principal use. Your table 8, which is basically requires a special use permit in the agricultural district. Section 5.3, which delegates, I believe, to your zoning board of appeals provisions that allow those zoning boards to impose special conditions. Section 6.7, your noise requirements.
Give me specifics there.
Your decibel requirements and your enforcement mechanisms, so 6.74 and 6.7.6. And then there's section 7.16, tall structure applications.
Specifically what?
Within this section, there's several at this point that we've identified. Again, some we may apply, some we may not, just for purposes of being overly inclusive. So we've got 7.16.4.D. Requires a certain paint, which we may be able to comply with, and may not. I would expect that to the extent it minimizes visual impacts, it's going to be something that our potential siting board would also be looking to apply. 7.16.4E, G, H, J, L, O, and P. Some of this is a little bit redundant, but 7.16.10.
What is that?
Site plan approval and special use permit required for Lex. Section B, C,
I'm sorry, section EC of what?
sorry,
B.
of 7.16.10.B. And then also C of that same section, F of that section, G, H, and J. But again, I just want to highlight that within each of those provisions, there are portions that we will comply with, and there are portions that we won't. So it's not a zero-sum game. It's not all or nothing. There's one provision within, one word within a sentence that we can't comply with. I've listed it here. It doesn't mean it's all being thrown out.
Well, I'm assuming you were gonna give us a printout.
We can do that.
List that you
Yeah.
got right there.
Again, with the awareness that this is going to be
It's not
a
set in
work in
stone, but
progress.
it's correct.
So this is the preliminary assessment of.
Of provisions within the zoning law that wouldn't
Okay.
be applicable.
And can I ask exactly what provisions within the Lyme zoning law will be cited in the article?
I'm not sure that there will be any within, except essentially taking your approval process away. Let's see, I think the only, in a waterfront district, there's no electric facilities that can be constructed in a waterfront district, so that's section 410, so that may or may not be applicable. Same with a floating plan development overlay, so if there's an overlay, again, there's no electric interconnection facilities can be built there. The town could impose reasonable restrictions and conditions upon an interconnection facility, so something, I think there'll be a dialogue over the interconnection. So, but I think for purposes of, I'm just presupposing the next question, which is, well, why aren't you coming to the town? We're going to Article 10 because it's one-stop shopping. We're going to be dealing with one entity that's going to impose one laundry list of conditions upon us. If we have to go to every state agency, local municipality, and negotiate different conditions, ultimately, we're never going to get the project approved. It's just, we would never be able to manage that process.
Did Mr. Chandler say he wouldn't come where he wasn't wanted? So you don't think we get the approval of the municipality?
I don't know what Mr. Chandler said, but that's not what I said. I said we're heading down the Article 10 path so that we can deal with one entity that'll impose one set of conditions upon us.
John
Isn't that what you said, Mr. Chandler?
I'm sorry.
That you would not come to a community where you weren't wanted?
I believe what I said was we have the support of the community here, which is why we would like to go forward with the project here.
But
And to
you don't want
John's
the,
point,
you don't feel you get the approval of the municipality then?
no, I don't believe I said that.
That's what Mr. Harris just said.
No, I didn't say that either.
What John said was consistent with what I said in October, which is The Article 10 process allows for a one-stop shop.
Mr. Chandler, if the Article 10 process was not in place, Article 10 process doesn't exist, would BP be talking to Cape Vincent still?
I think it's consistent with the October discussion about hypotheticals, and what we have again is a project that we're proposing here under consideration of the Article 10 process. We're looking for the town's feedback.
Were you saying, your hypotheticals, and I get that, what is your basis for assuming that, and to me it must be hypothetical, because what's the basis for saying that this community supports what you want to do?
I guess I'd say what's the basis for your assertion that the community does not want? We have landowners.
We have all elected people now who are not leaseholders. Do you presuppose that people who are appointed and elected don't represent their constituents?
What I would say is, we can't build a project unless we have people in the community that would allow us to come and build a
Sure.
project there.
Right. But 3.9% isn't the majority of this community.
What you're saying,
Yeah, I
though,
think we're
Richard,
getting a
is
little
that he's
off
got
track
the
in
support
general.
of the lessors who are willing to have their land used for wind farm purposes. And I think that's, the narrow interpretation of support of the community is, people, if by assignment or direct engagement with BP, have agreed to allow their property to be considered for this Article 10 application. It does not reflect that does not in and of itself reflect the spirit of the community.
So what would be, so what would,
PIP, then it wouldn't necessarily be.
yeah.
Well, that's his statement. I can't, but that's what that's what we seem to be saying, is support you got, obviously, is by people who have an economic interest in the outcome.
I'm kind of curious as to how many people in this room actually support your project as it's proposed.
Yeah, I don't know the answer to that question, but
Well,
I'm
can I get a show of hands?
go back to the agenda if we can.
Are you done with
Yeah.
going through the law, Mr. Harris? Or, I mean, I'm assuming it'd be easier for us if you really did provide us with a little listing at the end.
Sure.
But another
I have
question.
one question that goes straight to that.
Can I just finish?
Oh, all right.
What happens with this whole thing with respect to, I mean, it seems to hinge whether the project's gonna go forward or whether it's not, is on just what you outlined right there, and whether the siting board approves it. Whether it supplants other laws and puts our laws aside. It's very important. What is the suggestion? That's got to be, I'm assuming, critical for you as well, that this whole thing, your project's gonna hinge on. I mean, you said in effect that if our local laws, the way they're set in place here, if I don't misinterpret what you said the last meeting, is that it's important you wouldn't have a project otherwise. So what's going to be your position here if you're not able to convince the siting board to supplant and put our local law aside?
If the Article 10 siting board does not provide us a certificate, is that the question?
No. My question is, when we get to the issue
Yeah.
of these setting aside, just what you have right here, setting aside what parts of the law you want to set aside. If you're not successful in convincing the siting board to set aside these parts of the law, what's going to be your next step?
It's such a hypothetical, we don't know which
It's
local laws.
It's an easy one.
So none of the local laws is supplanted. If that's the case, there's no certificate to be granted. There's no place to put a turbine. There would be no project. So, if some of the local law is supplanted, then it becomes a business decision.
But John, we did not, you are aware, we did not rule out putting some here. You say if you can't supplant the law.
Under what's been proposed to date, the maximum size of turbine, maximum size, where under your local law, there is no project.
That's a business decision. That is not a.
I'm just answering the question.
Right.
I mean,
Okay.
there is no project. There's no place to put the turbine.
Not 124.